Well, you can legally request a modification in Texas at any time, but whether or not you're going to get that granted is a whole different story. So typically there has to be what's called a material and substantial change of circumstances. For example, within the first year after establishing an original order, then you have to have a danger to a child. You have to attach an affidavit with sufficient facts that allow the court to make a decision in your favor. So it's the more amount of time that has gone by, the more likely it is that you could potentially qualify. The other circumstance, though, is that it cannot be something that could have been and would or should have been anticipated at the time that you got the original order. Like, for example, well, the child is 14 now, therefore fill in the blank. Well, at the time of the original order, you knew the child was going to be 14. You should have anticipated for that. This needs to be something that was new. For example, the child started ballet and has qualified for the world championship, and the other parent won't take them during their time, and the world championship is important. So we're going to ask the judge and see if the judge will allow the child to go to the world championship. And the judge is probably going to make an order for makeup time. Could be another things. More commonly, it's something for like abuse or physical or some kind of complication that has come up. It's certainly less expensive and usually better if both parents do agree for a change. But if not, they can go back to court and the judge is going to make the determination. And the standard that they're going to use is, has there been a material and substantial change of circumstances? And then if there has been a material and substantial change of circumstances, then the judge goes to the best interest standard. Now you got to prove what is in the best interest of the child. And if you can prove that the change that you requested is in the best interest of the child, then you'll get the change that you wanted. If the child wants a modification at age 12, the child would get a voice to be able to go in and talk to the judge and express a preference. But just because a child wants a modification doesn't mean that they get it. If the child expresses a preference, that's actually deemed as a material and substantial change of circumstances. So that checks the box to get you past the hurdle. But now you go into the best interest standard. The judge has to determine whether the change that the child requested is in the best interest of the child. And if it is, then the judge will grant the request. If the judge doesn't think that it's in their best interest, the judge is more than welcome and able and definitely will not grant that particular change. So you got to get a good attorney to convince the judge. Yes, relocation is one of the most common things that does trigger a custody modification, because sometimes someone may have a right to move, but they haven't moved and everybody's gotten established, and maybe somebody's moved a few times and the other parent has chased them around, and now they're going to want to move again, and the other parent says, no, I'm tired of this, I'm asking that you be geographically restricted. That's very common, and those are usually pretty big fights, and some of the most difficult fights, especially if you have an involved parent on both sides. If both parents are involved and there's somebody that is under a geographic restriction and one of them wants to move, the one that wants to move is going to have a hard time overcoming and getting the court's permission to move. That's often a highly litigated aspect. If you have questions about modifying an existing court order, give us a call at the Palmer Law Group. We'd be happy to help you.